Hey guys, and welcome to today's video. We've got a few different sovereign citizens to cover across several courtrooms today. Before we get started, I want to apologize for the lack of content lately. I took an unexpected week-long break while traveling through Europe. That said, let's kick things off with a recent sovereign citizen appearance in Judge Perkins' courtroom. It's a short one, but we've got 4 videos to get through today. So let's begin.
Of Detroit versus Nathan Lucas. Case number Nathan Daniel Lucas. Case numbers SP 106-84961, SP 1111617, counts 1, 2, and 3, SP 11116371, SP 1129810, counts 1 and counts 2. SP 1389565, counts 1, 2, and 3. SP 9644961, 22737166, counts 1 and counts 2, and 227371. Appearance for the record, please.
Good morning, Your Honor. Tana Jenkins on behalf of Mr. Lucas. Mr. Lucas, please place your full name on the record.
Nathan Daniel Lucas, a living man.
A living man?
Yes, sir.
I would think that would be obvious, right?
No, sir. Not
No.
an etymology of the courts and the syntax grammar. No, sir.
You've gone above my head on that. I can't. That's above my pay grade. All right. So are you interested in a lawyer representing you, sir?
No, sir.
Okay. Are you interested in even getting a driver's license?
No, sir.
Are you interested in an offer at all?
No, sir.
Set the matter for trial.
Well, I intend to plead in the form of a demurrer, such that I do not acquiesce to quasi-jurisdiction.
AQU or AQUA. Because once you open your mouth, it becomes clear why you feel the need to clarify that you're a living man and not a living brain donor.
Okay.
Because that issue is to be brought up in my pleadings and filed with a court.
I didn't see any pleadings filed with the court. Do we have anything?
I said that is an issue to be brought up. My pleadings to be briefed and filed with a court.
Well, you should have done that. Today is the date and time set for arraignment on the bench warrant. Kind of here. I'll enter a not guilty plea on your behalf, sir. Give you a $0 bond. And I'll set a trial date for November the 14th, 2024. Or if you want a pre-trial date to file some pleadings, I can set that for October 21st, 2024. Which one would you like?
You could repeat that, sir?
Pre-trial date, if you want to file some motions, pre-trial date will be October the 21st, 2024. Or
that would be fine.
Just set it that you want that date?
October 24th, 2024?
October 21st.
21st.
2024 at 8:30 a.m. All right.
Yes, sir. And just for the record, I did not enter in no plea. I don't plead.
All right. Well, I'm entering in for you. All right. Have a good day, sir. I'll see you back October 21st, 2024, guys.
All right, that wraps up the first hearing, and it looks like we've got an interesting appearance coming up on October 21 SD. I'll actually be traveling again around that time, so you and I will be facepalming together from Amsterdam. Now, for the next hearing, let's head over to Judge Geyer's courtroom. This one involves a returning sovereign citizen I've covered before, who decided not to show up to court, earned himself a bench warrant, and was subsequently picked up by law enforcement, properly establishing the very jurisdiction he claims they don't have.
Good afternoon again, Your Honor. Custody on behalf of Trevor McLeod. All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
What's Goodish, one county prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter.
I do see that the new charge is set for an arraignment on September 10th it was at 10 a.m. You want us to continue this to the same date and time?
Yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking bad advice.
Bad advice? Are you kidding me? That's like saying eating paint for breakfast is taking bad advice. There are some things where bad advice is just another way of saying you knowingly did something stupid, especially when people like me are online actively countering this nonsense with basic common sense.
He's now retained counsel. To my knowledge, he had no failures to appear. He did fail to appear one time, which led to his incarceration and his sitting and bond being revoked. To my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had a lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you. Ms. Gitters, people's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender, 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract and ignore the case.
Wait, are you seriously saying I could just go out and rob people, then tell the court I don't consent to the laws, so I'm not accountable? Imagine all those stupid people wasting their lives in prison, not because they broke the law, but because they forgot to write in red edible highlighter that they don't contract with the government.
So this was really quite a willful refusal to acknowledge even the authority of the court, and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court, court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority and that he would appear. He's refused to appear and now has an absconding charge. So his bond will continue to be revoked until the conclusion of these cases.
As it should be. Let this be a lesson and some very real advice to anyone whose family depends on them for food and shelter. Choosing to not contract with the government while actively breaking the law can carry serious consequences. Now, let's head to Georgia, where we've got two sovereign citizens in wheelchairs, each making their own uniquely bad legal decisions.
What is your name, sir?
Whitlock.
Whitlock? All right. Mr. Whitlock, you have appears to be duplicate charges, so some of these charges are going to be dismissed, and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge, which is being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking, misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary hearing is currently set for September the 9th at 8:30 a.m. In regards to court-appointed counsel, Mr. Whitlock, are you working? Did you want to be considered for a court-appointed counsel?
Oh, no, I don't want court-appointed counsel, but I do not accede to I do not.
Hold on. So you're going to hire your own attorney?
Yes, ma'am. I don't consult to the proceedings, and I would like to say things like I already know how it goes.
I don't think you do, because what you actually said was that you don't consult or concede to these proceedings, when the sovereign citizen script clearly says you don't consent to them. And yes, there is a certain irony here, given that he's currently in a wheelchair while being charged with fleeing and eluding. That said, he's about to say something even more ridiculous.
With the things about crossing guard lines, I'm in a boot, and I was with the officer the whole time. I told them they need to use their cameras here because they found a bud of weed in my boots.
Your father's a detective, sworn to uphold the law, and you still think you can just not consent to it. I'd ask you to make that make sense, but there isn't enough thermometer juice in the world to pull that off.
Mr. Whitlock, you say you know what's going on, so you know this is being streamed live. So
I know, but that don't say I'd rather be charged for that than when they're putting on me. They found that on a water fountain. I don't even know what a water fountain is. I was with the officer the whole time. Even the officers in there said, "Man, this is gonna get thrown out," because the officers were just being an a-hole and putting everything on me. I had none of that. I was with the officer the whole time. You could tell them.
Mr. Whitlock, this is not a hearing. I don't have the officer here. So when we have the hearing, all this can be brought forward for your preliminary hearing or for, your attorney who you hire who can help you negotiate this. Again, I'm advised this is not a hearing. This is just to tell you what you're charged with. So any other questions?
If I say I do not consent with these proceedings though, and I do not accept the terms, like.
Okay.
Yeah,
well, you can discuss that with your attorney. If you have no other questions or comments, you're free to go.
Now, this one more question, ma'am. So
okay.
that with what you was just charging me with, that had in College Park, so is that a part of y'all?
College Park is in Clayton and in Fulton, sir.
Yes, ma'am. So I'm wondering, like, I thought I had to deal with Fulton County on that instead of Clay.
Looks like you have some Fulton charges as well, so.
Yeah, but the Fulton County charges is someone else. That's the way they actually locked me up and then let me out the hospital once he found out it wasn't me. So why they're still on me? Like
This charge, let me just tell you, the charge that you're for the aggravated assault that was in College Park, it is on or around July 28th. It happened. So that is not the Fulton County one that occurs that had happened around July 17th. So there's
Clayton County.
Yeah, if the warrant was sworn out for Clayton County, yeah.
Okay, ma'am. That's all I was asking. Because I know that's gonna get handled. That's some BS. But because I ain't did that. My father is a police officer, a detective, so I'm not worried about it. I know there's BS.
You can demand a bond all you want, but you were on probation and charged with new felony offences. Under Georgia law, specifically OCGA Section 17-10-1, any person on probation who is charged with a new felony must be held without bond pending a revocation hearing or a bond redetermination by a superior court judge. So no, you're not getting out of jail today. Now let's stay in Georgia for our final hearing, which is short but sweet.
But it's like this one thing. Those charges that I have in Fulton County, those warrants, I had got locked up in front of the legends on Old National. I know this not, I just want you to understand. I got locked up in front of the legends on Old National. I have 2% in the legends. The man even told him, hey, yes, he owner, he's an owner. And they still, hey, let me search you and all that. Now, once they searched and seen I was clear, I'm good. I know the officer, I buy them food. And the dude that was in, I also rent cars out. I have a Maserati truck I was renting out at the time.
Mr. Whitlock, I'm going to stop you there. Because you're doing too much. You're talking about Fulton County. I was trying to let you go for it and explain.
I need some professional help. Like.
Okay, well, you said you're hiring your own attorney, so they'll be able to help you with those charges, sir. Good luck.
I'm gonna have an attorney for the charge, but since you're a judge, you could tell me, like, why did they let me go? They let me go.
I can't tell you what happened in that case. I don't have those facts before me. I only have the ones I'm dealing with right now. So you're free to go. Thank you.
So what's my bond?
You have no bond because you're on probation.
I heard you give me a couple of numbers also.
There was for the misdemeanors, there's like $1,000 and $1,500 for the remaining felony charges. Those statutes don't allow a judge to give you bond if you're on active probation for felony charges.
Yes, ma'am. But even in Fulton County, they don't allow.
It's the laws of Georgia, yes, sir.
Okay. I thank you, ma'am.
You're welcome. Have a good day, sir.
Mr. Williams, you are.
You say, talk to my lawyer, right?
Yep.
And even if I say I demand a bond immediately,